So this is the second appeal, Lordship, from the concurrent finding of the learned court below, Lordship. The substantial question of law that in page number 9, Lordship. 1 to 3 is the main substantial question, Lordship. On 2 and 3, Lordship. No, not Lordship. May I suggest one thing? The question number 2, it may be taken as that whether the learned court below misappreciated the evidence laid at trial. So it will include the parameter of substantial question 2. The learned court below misappreciated the evidence laid at trial. So that is the gist of substantial question number 2. Lordship. That's all, Lordship. Grateful, Lordship. Lordship, on can is there, Lordship, for rest operation of the. Can नहीं है, इसमें नहीं है. I may be pardon you, Lordship. I'm sorry, Lord. ठीक. Lord.
My lord, respondent number 1 received the copy, my lord, but he is residence of Campbell Bay. I could not receive the Wakalatnama. Then let the matter be fixed on Wednesday or Thursday. I will receive from through speed post, my lord. Yes. Obliged.
Lord, I do one thing because the government pleader used to appear for the respondents. I just serve a copy and intimate that the matter is fixed on Thursday. Through my letter panel, I will communicate. Oh.
Item number 3, MAT 125.
This appeal be taken upon either on Monday or Tuesday. Monday or Tuesday. Or Tuesday, no? On Tuesday. Monday. I'm grateful.
Item number 4.
Same position.
My lord, I am appearing for the private respondent in this matter, my lord.
I am
filing
appealing
my
for the
Wakalatnama.
respondent number.
You can, this may be taken up, my lord, because I will be traveling back to Kolkata. I am not a local councillor. So I will appear on VC on Monday. Sir.
Lord, I'm for the respondent 3 and 5.
Great.
Item number 5, MAT 52 of 1025.
But even I appear for the Port Blair Municipal Council, but even we have not received the copy. Lord, Municipal Council, Lord, but I have not received the copy.
Not affected, we have dispatched, but yet to be affected. Dispatch to speed mode. Next second, next second. Item 6.
Your Lordship, I am for the petitioner.
I am for the respondent.
Your Lordship, here the petitioner, she was appointed in 2002. And approximately 24 years have passed. She's still working in the department. Similarly situated persons have already been regularized. They have been appointed also. And she has been discriminated. And the chart showing that thing, I have already described in my case. Your Lordship, we kindly come to page number 21 of the paper book. One paper book I have given you. Yes. Page number 21, Your Lordship, may kindly come. Augusta Kajul is the petitioner. Now kindly see, Your Lordship, I have mentioned that how, when they were appointed. This is Augusta Kajul, Pushparani, Manjula. And I will show from the orders of appointment also, that is all orders. These three names are here together. Pushparani, this Augusta Kajul was appointed on 19th March 2002. Pushparani also same day, 19th March 2002. And Manjula was appointed afterwards, 15th July 2002. She is junior basically. Now, Your Lordship, the various orders are there, and I have mentioned. Your Lordship, may kindly come to page number 23, last paragraph what I have written. As the authorities did not comply with the order. This is Pushparani Satsma. About her, I am just mentioning. As the authorities did not comply with the order and passed another order on this, rejecting the candidature of the applicant by holding that applicant is granted age relaxation. As such, she can apply for the post as and when vacancy is notified. The applicant filed original application before the tribunal bearing OA number this, and the Honorable Administrative Tribunal on this directed the authorities to appoint the applicant at par with Mrs. Manjula. A WPCT was filed bearing WPCT number 168 of 2021, and the Honorable High Court, after hearing the parties, dismissed as an application on 16th March 2022. The respondent authorities prefers special leave petition, which was discussed on this. On 1st September 2023, the respondent authorities issued appointment order in favor of here. That Pushparani. I am asking for the same benefit what has been given to her. Now, Your Lordship, I will show that how they are similarly situated. Kindly come to page number 82. Now kindly come to page number 83. This is the appointment order. Number 1 is Pushparani. This was. Number 5 is Augusta Kajul. Now all are up to page number Page number 144, from 84 to 144, all are appointment orders. That has been given after the expiry of the period which is initially mentioned. Then they were appointed for 1 year, 6 months. So all orders are there. In all these orders, Your Lordship, the name of Pushparani appears, Manjula also appears. Now, Your Lordship, this is the first one, page number 86, one by one, just I'll show. Page number 86. Serial number 14, 30, and 34 may be seen. 14 is Manjula, 30 is Pushparani, and 34 is Augusta. And up to 144 page number, I don't want to show you, Lordship, over point by two. This page number 80 to 88 also is there. Then 90 also, all appointment, all three names appears together. Yes, yes. They all are part-time craft instructors. These examples I have given about two persons. There are many. I have annexed the appointment orders of them. One is Geeta Devi, one is Babita. All those persons have also been regularized. Appointment orders have also been issued to them. So I am praying that similar benefit should be given to me. That thing the tribunal has overlooked. The tribunal did not consider that. Tribunal was insisting upon an old order passed by the tribunal itself in 2008 in respect of my case, where I have not been considered for regularization, because at that relevant point of time, these judgments were not there. But subsequently, Pushparani Biswas was also given. Manjula has also been given. So these things were not at all considered by the tribunal. So I am just seeking same benefit, similar benefit, which has been given to these people. Yes. Page number 235.
मेंशन करेंगे चेक लेने का ऑर्डर कराना भूल गए हम जो 25,000 जमा किए थे ना वो वापस लेना होगा.
No, this is a vacancy notice, my lord. I just show you notes.
That is a vacancy notice.
Which is at 117, 77.
And was placed in the ineligible list. So that is a vacancy notice advertisement.
177 was then. 77.
My main prayer is prayer C. I have specifically mentioned an order to issue directing the respondent to treat the applicant at par with others similarly situated part-time craft instructor appointed on regular basis. Wait. Yes, similar was the situation of Pushpa Rani Viswas also. I have annexed. Yes, for age relaxation. That has not been given to either to her, even to me, it was not given. But our point was that we have been working. She was also working for many years, and now it is 25 years running for me. Still, I am working. Still working. I'm still in job. Yes. Yes. And my counterparts, all other persons, main persons, they have already been regularized. Your Lordship, may kindly come to page number 230. This is the order in case of Pushpa Rani Viswas. Now, Your Lordship, may kindly come to the operative portion I showed. In the paragraph 10 may be seen, Your Lordship. In the absence of any reference by the Department Selection Committee and the consideration of the result of trade test and interview of Ms. Manjula, it cannot be said that she was put to any trade test or interview, though the memorandum dated 5/7/2012 suggests for the same. Accordingly, the contention of the respondent is unsustainable and untenable. On the other hand, this tribunal on more than one occasion, while relaxing the age limit for the applicant, held that she is entitled for appointment on par with Ms. Manjula. In the circumstances or the reasons mentioned, the OA is allowed and the respondents are directed to appoint the applicant by considering her case on par with Ms. Manjula. And thereafter, they went to the Honorable High Court. It was dismissed. Went to the Supreme Court. That was also dismissed. And then they gave appointment to this Pushpa Rani. I am praying for a same order. They cannot say that I am not situated, I'm not similarly situated with that of Pushpa Rani Viswas. They can't say. She is also craft instructor music. I am also craft instructor music. Tribunal rejected because the tribunal has considered an order which was passed by the tribunal in 2008. With regard to my appointment, regularization cannot be given. So the tribunal is insisting upon that particular order. Order is they have mentioned here actually.
No.
Yes, that is the point. I have not challenged that order because till that time the cases of other individuals have not been considered because this order was passed only in 2018. So this time when I have filed the original application, I have relied upon this decision. decision passed by the tribunal in Pushparani Biswas case and in Manjula case. I said similarly situated person, subsequently, the order has been passed and they have been regularized. So I should also be considered similarly like that of those persons. That is my case. But tribunal just considered that particular order and passed it. This is basically this is a fresh cause of action because all the decisions relating to other individuals were taken after that. Manjula, it was taken in 2012. This is the, I have annexed the order, that was order also. Just a minute. I have annexed all the judgments, Your Lordship. The parent one, Your Lordship, it was in respect of other individuals also, that is there in page number 157. There also a detailed discussion was done. Just 1 minute, Your Lordship. Page number 228, Your Lordship. Page number 228. (220). That is in case of Manjula, the Honorable High Court has passed the order. Yes, Your Lordship. The peculiar thing is that, Your Lordship may kindly, Mr. Mandal, the last paragraph. Mr. Mandal, learned government pleader, submitted on instruction that his clients are agreeable to give the same treatment to the petitioner before us as was given to the applicants in OA number this, and this. The offer given by Mr. Mandal is a fair one and is also acceptable to Mr. Prasant. Accordingly, the order dated 12/1/2012 passed by Learned Tribunal is set aside and substituted by the following order. The state respondents are directed to extend the same treatment as was given to the applicants in OA number this is as early as possible. And then Manjula was appointed. Yes, this is Manjula. I am also saying the same order may be passed. The treatment which has been given to Manjula, Pushparani Biswas and the cases in OA number, the same treatment may be given to them. My argument is that, Your Lordship, whether it is a court or whether it is the authorities, nobody can discriminate. Even the court cannot discriminate between two similarly situated persons. So when the authorities have extended the benefits to others, their benefit should be given to me. And moreover, I can think, Your Lordship, that benefit should not be given to me had I not been working and terminated from the service after the disposal of the matter by the tribunal or prior to that. I'm still working. Today also I'm working. It's not 25 years. I have two judgments of the Honorable legal judgments on it. So this is the first one. Yes. Earlier once.
No.
Same was the position of Manjula and Pushparani Biswas also. They also took part in the, they were not successful, but the authorities continued them. Same position. And the authorities continued them also. So far as myself is concerned, I was also allowed to continue. If I was not successful, I should have been terminated at that relevant point of time itself. But it was continued. I'll just show it. Years. 25 years. Yes. 2002 was the initial appointment, and now we are in 2025, end of 2025. So approximately 25 years. More than 20 years at least. Yes, yes. Now, Your Lordship, I have specifically mentioned. Kindly come to page number 22. Yes, Your Lordship, I'll just refer, Your Lordship. This I will show this one and I will refer. 22, page number 22 of the paper book. Actually, I'm specifying with regard to Pushpa Rani Biswas. Your Lordship, so far as this petitioner is concerned, she was placed in the list of ineligible candidates. She was not allowed to participate in the selection process. But Pushpa Rani Biswas, she was allowed and failed. And we have specifically mentioned here. Page number 22, the third paragraph. Page number 22, the column is there. The third row. Respondent authorities place the candidature of the applicant in the category of ineligible candidates with a order dated 6/11/2015. That column I have prepared. The third row may be seen. Page number 22. Third row, Your Lordship. Respondent authorities place the candidature of the applicant in the category of ineligible candidates with a order dated this. On 23/7/2008, the respondent authorities held that the applicant cannot be considered for appointment as she was given opportunity to qualify in the selection process, but she failed. Pushpa. Upper. Yes. Agastha Kanji. What I am saying, the person who failed, that person has been regularized. Even that person has been regularized. But so far as I am concerned, I have not been allowed to participate in the selection process. I was put in the ineligible candidates list. And now the position is that the tribunal is also not considering that similarly situated persons have been given appointment. Even that person who has failed in the examination, that has also been considered. Your Lordship, the judgment which I have relied upon. Here, your lordship, it is. Here, paragraph 11, basically paragraph 11 and 12. Long and uninterrupted service, your lordship. There is no argument by the other side, your lordship, that I do not fulfill the qualification. I have got full qualification, your lordship. So the Honorable Supreme Court has considered the long uninterrupted service of that particular individual and granted relief. Sanction post, yes. That's why they have been advertising the post, which goes to show that posts are there, sanction posts are there. And against the sanction post only I have been appointed, your lordship, because after our appointment also advertisement was made. When I was putting the ineligible candidates list, that time advertisement was there, which goes to show that vacant posts are there. And against those vacant posts only we were appointed. So that plea they can't take that sanction post was not there at that relevant point of time because they have advertised the post. No, your lordship, with regard to your lordship, this is another judgment where similarly situated persons have to how they have to be considered, your lordship, that is mentioned. Paragraph 15 to 18, your lordship. Why I am showing this particular judgment specifically, your lordship? Because when Manjula was considered for appointment, I have just shown, your lordship, what the authorities have said. That they are agreeable to give the same benefit as it was given to others. And then Manjula was appointed. Here also, your lordship, it is not the court's order. Basically, court has just said what the authorities are saying. The court has passed the order. Yes, the authorities are agreeable, so give that benefit. But without that order also, the authorities were agreeing to give that benefit. Here also, your lordship, the authorities have regularized the service of one of the incumbents on their own. And then the court has said the similar benefit has to be given to that candidate also. I'm showing the recent judgments, your lordship, of the Honorable Supreme Court. Because there are many old judgments that I'm not showing because sometimes the Honorable Supreme Court is saying, no, it should not be regularized. Sometimes the Honorable Supreme Court says, no, it should be regularized. So I have brought the recent one. This is another one, your lordship. It is of 2024. That was 25 also. This is 24. There, your lordship, the Honorable single judge has issued a mandamus directing the authorities to regularize the services of the incumbents who have worked for more than 10 years. Here I am running exactly, if we are mentioning, 23 years. Now, your lordship, the matter went up to the Honorable Supreme Court. Supreme Court has said that this decision is correct. And direct order has been given. The authorities have been directed to regularize the services. Paragraph, Your Lordship. Paragraph 9. The direction has been given that there was some contempt application and the litigant have been approaching the court from time to time, like me only, Your Lordship. I have also filed so many original application in the past. And direction has been given to regularize the services. And then, Your Lordship, this is one more judgment. Here, Your Lordship, the Honorable Supreme Court has held that a person who is working for such a long period of time, here that particular person was working for 25 years and 23 years. So the court has said that this temporary nature of the work should not be now at this stage, after so many years, should not be considered that it is a temporary nature of work. It is a permanent nature of work. And then the court has said paragraph 5 and 8. I'm just placing, Your Lordship. Having heard the arguments of both the sides, this court believes that the essence of employment, the rights thereof, cannot be merely determined by initial terms of appointment when the actual course of employment has evolved significantly over time. The continuous service of the appearance in the capacities of regular employees performing duties indistinguishable from those in the force and their selection through a process that mirrors that of regular appointment constitute a substantive departure from the temporary and scheme-specific nature of their initial engagement. Moreover, the appellant's promotion process was consecutively overseen by this, and their sustained service for more than 25 years without any indication of the temporary nature of their roles being reaffirmed or the duration of such temporary engagement being specified merits a reconsideration of their employment status. And in paragraph 8, Your Lordship, direction has been given. Though they have termed part-time, but Your Lordship can understand that from 2002 till today, I'm working there. If it was only temporary and if it is not, I'm not required in that particular post, there was no necessity for the authorities to keep me in that particular post till today. Even after losing the case before the tribunal. That is more important, Your Lordship. In 2008, it was rejected. From 2008, after that also, till 2025, I'm working. This goes to show that I am required in the department. The nature is permanent. So my submission is that, Your Lordship, similar order may be passed and this particular person should not be made to suffer anymore. She is already 56 years old. And after 4 years, what the authorities will do, Your Lordship knows, if I'm not given the benefit, I will not get any pension. So they will keep me in the post. That is for sure. Because they don't have any other person in that particular post. So they have to keep me there. So it's only 4 years left. If I'm not regularized, Your Lordship, I will not get any pension. No pension anyway. So my submission is that, Your Lordship, the authorities be directed that what benefits have been given to Pushparani Biswas and Manjula, same benefit may be given to me. This is my submission.
Lord, my first submission is, Lord, as there are series of Supreme Court judges, which basic principle is Uma Devi. Lord, because even in recent judgments of Jagpal, that matter also, the Supreme Court has directed to consider the part-time contract employee. They taken the principle of that Uma Devi only. Based on that, there should not be any unfair practice to the persons who have been, you should not be humiliated. So that is what the views of the Supreme Court. Now this instant case is entirely different. What are the argument made by the appellant before lordships? That was not the case before the tribunal. Lord, the main case before the tribunal is what? Time to time vacancies were advertised. 2005, 2008, 2011, 2015. She participated in 2000. 5 vacancy, she found to be unsuccessful, she had not qualified the trade. Then again, 2008, she participated, not qualified. Again, 2011, now 2015. Whenever a vacancy was advertised, she used to jump to the tribunal saying that vacancy was arised. I didn't be allowed to be. That was the case, regulation. She is emphasizing on this. But the regulation has to be judged based on the individual veracities of each applicants, their candidature, their appointment orders, their performance, everything has to be judged independently because the parity in the regulation is cannot be considered. This is my first submission, my lord. My lord, that's why I'm coming, my lord. My lord, may kindly, yes, my lord. My lord, may kindly come to page number 169. My lord, Augusta Kujur, she is the applicant. She is the petitioner as another applicant in the OA. My lord, I just read the order 169, my lord. In this way, the applicant is paid for regulation of a service as a craft instructor in music under the respondents. The case of the applicant is that she was engaged as a craft instructor music and government senior secondary school Diranipur, Podla in the year 2002 on a consolidated payment of rupees 800 per month. She was continuing the said post on part-time basis. Since then, the salary has also been increased in the meanwhile. She is otherwise eligible as per the provision of recruitment, but her case was not considered for regulation. She made several representations and had earlier filed an original application OA 51A 2005 before this tribunal, which was decided on 15/9/2005, directing the respondent to consider a case for regulation appointment in terms of the recruitment rules. Pursuant to the said direction, the respondent authority issued an order dated 8/12/2005 rejecting her case. Challenging this order, she has once again filed OA praying for regulation of part-time service as a craft instructor. The respondent has filed a reply wherein they have stated the pursuant to the direction of the tribunal in the earlier OA, the applicant was allowed to appear in selection test held earlier against 3 notified vacancies. 34 candidates include the applicant took part in the selection process, but the applicant could not come out of a successful and therefore she could not be regularized. However, she is still continuing on part-time basis. We have heard the counsel for the parties and perused the documents placed before us. On going through the document placed on record, we find that although the applicant was already given an opportunity to take part in the selection process for regular appointment held on last occasion, but she could not come out successful. The learned counsel for the applicant has pointed out that there are still vacancies and therefore the applicant case may be considered against the vacancy. However, it is now held by the Honorable Supreme Court in the case of State of Karnataka by Sumadevi 2006 4 SSC 1 that irregular appointment cannot be regularized, that the casual or part-time employee do not have a right to appointment without following due process of recruitment. Only because one is a continuing for a long time on casual or part-time basis does not confirm any legal right on such part-time or ad hoc appointment to get the regular appointment. In view of the legal position stated above, no direction can be issued to the respondents to regularize the part-time appointment of the applicant. However, since the applicant has been continuing for a long time, even after failure of the last selection, she may allow to continue. Not the applicant before Lordship is saying that she was allowed to continue. She was allowed to continue in terms of a tribunal's order. And that to be, it is specifically mentioned before the tribunal that the regulation case cannot be considered. And this order she is never challenged, which attained finality. But this was not the case with regard to Pushpa and Manjula. And why with the direction that the applicant be given further chance to next selection as and when it will be notified, provided she is otherwise eligible as per the provisions of recruitment rules. Until such selection is made, a regular selected candidate is appointed, the applicant may not be disturbed. We are passing this order in view of the dictum laid down by the Honorable Supreme Court that an ad hoc appointment should not be displaced by another ad hoc appointee because such ad hoc appointment has granted experience which will be more beneficial and useful to the regulation rather than to appoint a person afresh on ad hoc basis. Lord, she initially approached for regulation. 2008, the tribunal has specifically passed an order that the case for regulation will not be considered. And based on the tribunal's order, she was allowed to continue. And not the authorities. Lord, this factual aspect is not in connection with Pushpa Rani or Manjula. No, let them, because they say the parity with regard to Manjula and Pushpa. Well, once you approach before court of law, and the court of law has decided that you cannot be regularized, you could have challenged it, saying that the tribunal is wrong by passing an order. They have admitted their position. And the tribunal also said whenever a vacancy arises, you will accommodate, you will allow him to participate subject to the recruitment rules, which has been prevailing at that point of time. When a vacancy has applied, 2015 is the cause of action she shows in the incident original application, saying that and vacancy was published in 2015. That was a notification which was scrutinized, and she became as aged about 46 years. And after granting relaxation, she will not come under the zone of consideration. As such, her candidature has been found under ineligible list. Immediately, she rushed to the tribunal, saying that the tribunal, before the tribunal, saying that there is an incident where, well, Lordship was perusing the impugned order in question, that the tribunal has said no interim relief has been granted, neither the selection process has been stayed by the tribunal. The tribunal has acted to file a reply. We have filed the reply, and at the time of final adjudication, the tribunal has considered this aspect also. The order passed by the tribunal, but the tribunal cannot sit and appeal over his own order. Because once a tribunal is passed saying that you cannot be regularized, can a tribunal again can sit his own order and say that no, they should be regularized? Because it has to be decided by the higher authority. But in the instant case, she accepted the position. She accepted the position that I am not to be considered for regularization in terms of the tribunal's order. She is only giving answers when the vacancy advertised, why she has been made ineligible. But I could have been note from the prior lordship, because if her case would have been that instead of going to challenge that ineligible, her case could have been saying that why my case not been considered for regularization. Instead of challenging the selection process that in the instance selection process, this is 2015, notified by the authorities, I've been made as ineligible candidate. She instantly that she could have filed an application for regularization, saying that I am entitled for regular at par with Manjula and Pushpa. That was not the case. The case is I am made ineligible. As such, I am to be considered because at par with others, those who have been given appointment, and she has given reference to two persons, that Tiwari and Babita Devi, they both are participate in the duly selection process. I'm sure the lordship mindly come to the orders, which has been referred by the applicant in the OA. Well, there should be some pleadings.
Manjula and Pushpa.
No, I just
Tell us Manjula and
I'm
Pushpa.
saying that is what pleadings before the tribunal. Well, I am duty bound to be place the records. Lords are sitting before us a judicial review of the tribunal, whether the tribunal has passed an order in accordance with the provisions of law, or where there is any infirmity which the order passed by the tribunal. When you approach before the tribunal, what is the case before the tribunal? You have placed the case before the tribunal is a different manner, and you are making a new case before this honorable court. May not may kindly come to the pleadings part. What they made a case before the tribunal. My lord may kindly come to page number 55. My lord, the ground number 3. What are the parity they are seeking for? For that the similarly situated person, more specifically, may I read, my lord? For the similarly situated persons, more specifically applicants in OA number 112A in 2005, Ram Prakash Tiwari, and OA number 71A in 2006, Mr. Jayasri, have already given regular in compliance of the direction passed, but as such, the applicant cannot be treated as a dissimilar manner. Not except this averment, there is no whisper with regard to Manjula, with regard to Pushpa, how the parities are being given, what are the more, nothing has been mentioned in the original application. The tribunal will decide based on the application which is put forward before the tribunal. What are the pleadings which is put forward before the tribunal? We have submitted our reply. We have clarified in our reply position that both the persons have duly participated in department selection process as granted to others also. They have qualified, they are given appointment. They have not been pick and choose manner, they have been done. They have participated in the selection process, they qualified, they have been given. I can show one orders which will be clearly. My lord, may kindly come to page number 224, my lord. 224. there is order number 5024, my lord, dated 25th November 2004. In compliance with the Solomon direction by the High Court Central Administrator in order number 19/6/2004 in OA number 57 2004 on the recommendation of Department Selection Committee, which met on 13/10/2004 and relaxation of age of the honorable conveyed at 2004, the Director Andaman Nicobar hereby order appointment of Babita Devi to the post of clerk with effect from 4,500. Not the Department Selection Committee, she has participated in selection post. After that only she is appointed. This is my first submission. Not with regard to saying that the Manjula and Pushpa, the OA which was filed in the year 50A in 2004, my lord. I
Yes,
think that
they-
orders
two-
222.
226.
Yes, my lord, kindly read, my lord, page number 223.
Yes.
I'm sorry. No, it is not regulation. It is Department and Selection Committee. She is duly in terms of the recruitment rule, the tribunal's order, she has been given. My lord, now, my lord, may kindly come to the prior portion of the original application. My lord, page number 56. Lord, I read, my lord, prior A, an order to issue directing the respond number 5 to delete the name of the applicant from the list of ineligible candidates prepared and signed on 6/11/2015. Lord, this is the first prayer. She says, in terms of the vacancy notice, she become found to be ineligible. I come why she becomes ineligible. With regard to second prayer, an order to issue directing the respondent to grant age election to the applicant in terms of circular dated 6/6/2001 and 19/9/2011, and to appoint the applicant to the post of craft instructor on the basis of academic weightage, marks, and experience. She is making this second prayer.
There's.
Yes, an order to issue directing the respondent to treat the applicant at par with other similar situated craft instructor appointed on regular basis. Lord, the OA was filed in the year 2015. Who are that at par? That I showed that Babita Devi, Jayashree, there are the at par. So the tribunal has to judge based on that three persons whether they have at par to be treated with them or not. This was the case before 2015, before the tribunal. Now, my lord, kindly come to the vacancy notice. Hundred and 177, my lord. My lord, I'm sorry, it is an extract of the advertisement. My lord, I just take my lord's note 2, right hand side, my lord, right hand side, from the top, note 2 has been given, my lord. My lord, got it, my lord? First paragraph, right hand essential qualification. In that line, my lord, below, that is note 2. The age relaxation allowed as per the administrative circle dated 19/9/2011 will not be available separately and will be subsumed in the age relaxation allowed as per the note 1 above. So, my lord, the circular, she is saying that second prior with regard to saying the circular 2011 and 2001 should be considered because in the advertisement, specifically attachment that cannot be an additional based on this circular. So, she at the time when she applied, she was found to be as a 46 years. So, she is not come under zone of consideration of age relaxation. She is found to be ineligible. My lord, may kindly come to 179. Note serial number 5, 179. Serial number 5, my lord, Augusta Kujur. General category, age 46 years, overage. Lord, this was the case. She put forward this case before the tribunal, and the tribunal has not granted any interim relief. Rather, tribunal has not saved the selection process. And after this, my lord, may kindly come the impugned order which is passed by the tribunal. The tribunal has taken all the aspects. Lord, I take Lordship's kind attention towards page number 238, D, my lord. I may permit you to read, no? The respondent issued recruitment notice in September 2004, filling up of backlog vacancies, that is 7 posts of tailoring, embroidering, 1 post of craft instructor music. The applicant applied for the post of craft instructor music on 23rd 10 2008, but not to avail. On 24 2015, the respondent issued forth with recruitment notice. Thereafter, Athma excluded the applicants from selection process on the ground of overage and order dated 6/11/2015. Hence, this way. No, the respondent have filed the written reply refuting the claims of the applicant. In reply, the respondent stated as under. Pursuant to the order of this tribunal on 15/9/2000 in the OA 51A/2000, the case of applicant was considered in terms of the recruitment rules, and a speaking order dated 8/12/2005 was issued, rejecting her case on the grounds that she was not qualifying the selection process for those of craft instructor music as per the recruitment rules. Thereafter, the applicant has filed a contempt petition, CP number 08/2005 before the tribunal, which was dropped by the order dated 22/12/2005 with the liberty to file a separate OA. The applicant has filed another application before OA 69/2008 before this tribunal, which was disposed of by the order dated 10/12/2008 with the direction to give the applicant a fresh chance in the next selection and when it would be notified, provided she was otherwise eligible as per the provision of recruitment rules. Not the 2008 order which I shown, she has not challenged it. The tribunal has taken consideration to that order also. She was otherwise found eligible as per the recruitment rules. Until such selection was made, a regular selected candidate was appointed. The applicant should not be disturbed. As per the respondents in order, in the said order, it was observed that in the proceeding paragraph that only because one had continued for a long time on a casual or part-time basis, it do not confer any legal right on such part-time or contract appointment to get regular appointment. In the said order, the judgment of Honorable Supreme Court in the case of State of Umadevi, State of Karnataka versus Umadevi, 2006-4 SSC 1 was referred, and it has to be observed that irregular appointment cannot be regularized, and a casual and part-time employee has no right to get regular appointment without through the process of recruitment. The process of further stated that the applicant could not succeed in selection process. Therefore, her case could not be considered for regulation recruitment. The respondent have also stated that this tribunal has not granted any stay order in respect of the recruitment notice, and after publication of the last recruitment notice in the 2015, the applicant not prayed for regulation. Therefore, her case could not be taken into consideration. Therefore, his OA is not maintainable and is liable to be dismissed. The applicants filed a rejoinder after hearing learned counsel for the applicant and submitted admittedly. The tribunal has not issued any direction to regularize the part-time appointment of the applicant, but it has not prevented the authorities of treating at par with the applicant to other similar OAs. Now, the tribunal was very cautious on this aspect. Learned counsel for the applicant has further submitted the pursuant to the common order dated 24/5/2007 in OA number 112A in 2005. OA number 71 and 2006, the applicant who are also similarly situated applicant in incident OA have been given regular appointment as per this selection process commenced with the advertisement dated 8/7/2005. No, this was the finding of the tribunal in the other person that they're saying at par with, treated to be at par with them. The tribunal specifically said, no, have given regular appointment as selection process commenced with the advertisement dated 8/7/2005, wherein she also participated, she became unsuccessful. But case of the applicant for regulation recruitment was not considered in proper manner. Finally, her name was listed in the list of ineligible candidates on flimsy ground of overage by order dated 6/11/2000, which is biased, scripting, and contrary to the principle of natural justice. Therefore, the learned counsel responded as led and reply as submitted that as per the orders of the tribunal, the case of the applicant was considered as per the recruitment, but finally the case was rejected on the ground of overage. The learned counsel for the applicant responded further submit the applicant has not got legitimate right to claim either for regulation or part-time service against the regular post of craft instructor or for age election beyond the permitted limit after getting declared ineligible by the defendant. There was no violation of rules, regulations while considering the case of applicant. Therefore, the OA should be dismissed. Heard the learned counsel the parties and perused the materials on record. Admittedly, the applicant was appointed on craft instructor on consolidated pay on 19 March 2002. With the direction 2000, she has filed an OA which was disposed of by order dated 59/2005 with the direction to the respondent to consider the case of the applicant in the light of the earlier orders passed by the tribunal on the same issue and to take steps to appoint her as a vacant post in terms of the recruitment rules. In the meantime, recruitment to the post of craft instructor, Director of Education was notified on 10/11/2004 through gazetted notification, wherein the method of recruitment has been stipulated, serial number 11, which is as under. Now, next page, page number 8. Thereafter, one notification dated 8/7/2005 inviting application for filling up a post of craft instructor was issued with closing date 26/7/2005. Wherein an age limit for appointment as a craft instructor for female employees was mentioned as 10 to 37 years. In the meantime, one Sri Ram Prakash Siwari and Ms. Jayashree have challenged the recruitment published in 2004 and the recruitment notice dated 8/7/2005 before the tribunal and which is disposed of in common order. We are in the Honorable Supreme Court in A. N. Sastry versus State of Punjab was referred and the respondents were directed to follow the drill as followed in the case of the applicant in the said case. In the instant case, pursuant to the order of the tribunal dated 59/2005, the Director of Education, Andaman Nicobar Administration rejected a case of the applicant by the order dated 8/12/2005. Thereafter, the applicant has filed a contempt petition before the tribunal, which was dropped by dated 12/2/2005 with an observance in the post selection post. Director of Education has stated that all the three candidates have been selected according to merit. Therefore, we do not find no reason to hold there is a contempt of order by the response. However, applicant would be at liberty to question the selection. This was the liberty granted to them to question the selection. As said, they questioned the selection. Pursuant to the said order, the tribunal, the applicant has filed another application being OA number 66/2008 before the tribunal, which was disposed of by the order dated 10/12/2008 with the following directions. No, I will not trouble as I pointed out, the 2008 tribunal's order. That order has been quoted. Another, again, last paragraph, again, another recruitment notice was issued in 2009 for filling up the backlog 7 vacancies of craft instructor, tailor and embroidery. One post of craft instructor music, the applicant applied for the post of CI music pursuant to the said notification. Thereafter, a respondent issued recruitment notice dated 24/2015 for filling up of 9 posts of music, vocal, instrumental. As per the said recruitment notice, the recruitment rule prevalent at that time, the applicant was not found eligible due to her age even after getting 5 years age relaxation, because at the point of time her age was 46 years, whereas the age limit for female candidate for craft instructor music vocal instrument was 18 to 38 years as per the said notification. On perusal of the above, it is clear that though the applicant had on earlier occasion asked for regulation, a request was turned down by the tribunal by the order dated 10/12/2008, which was not challenged before the higher form, and therefore the judgment of the tribunal had attained finality. However, as per the direction of the tribunal, she was permitted to apply for 4 occasions against the different recruitment notices and she did not qualify though she participated in the examination. Finally, at the time of participation in last notification 2015, she was found overage as her date of birth is 3/5/1969 and as on 29 May 2015, she was 46 years old. As per the notification, age limit for female candidates was 18 to 38 years. Relaxation up to 5 years for government servant, ST candidates, 3 years OBC candidate. Therefore, even after getting age relaxation, she was not found suitable for the post. Now, the recent Supreme Court judgment of the apex court in the case of Union of India and others versus Ilma Devi and another, the principles, my lord, the 8.7 has been quoted, my lord, that as per the law laid down by this court and opposite decision, part-time employees are not entered to see regularized as they are not working against any sanction post. There cannot be any permanent continuation of part-time temporary as held. Part-time temporary employees in a government-run institution cannot claim parity in salary with the regular employee of the government on equal pay for equal work. In view of the above aforesaid discussions, it is clear the part-time temporary employee have no legal right to be regularized. In view of the dictum of Honorable Supreme Court in Ilmo Devi Supra, we find that applicant is not entitled to get age relaxation as per the circular dated 6/6/2001 and 9/9/2011. As per the laws laid down by apex court in various judgments, one cannot challenge the selection process after taking part in the same. Since the applicant has appeared in the selection process, she has lost her right to challenge the same and claim appointment afterwards. Thereafter, the claim of the applicant for appointment as a craft interviewer was rightly turned down by the respondents as per the rules. No interference of the court is called from this matter in which. Yes, my lord. She becomes unsuccessful, my lord, because that's what the tribunal has said. Age. My lord, she all along when was vacancy was published, she participated in terms of the 2008 order. That's for 4 occasions. The tribunal there are 4 occasions. The last occasion is 2015, where in 2015 she is found to be overaged. There are 2 modes of selections. If I can show it from the vacancy notice. First, you have to, based on the merit, self-based merit system, a list will be prepared. Thereafter, because it's a craft instructor, tailoring and embroiderer, so we have to take the trade test. As per the trade test, we have to cut off marks has to be qualified in the trade test. If you are not qualifying in the trade test, you are not to be given an appointment. So she is not qualifying in the trade test on 3 occasions. On 4th occasion, when she is on 2015, she applied. At that time, she was found to be overaged as 46 years. So they are determined under the category of ineligible 46. So then she went to the tribunal saying that I have been overaged. She challenged that part. She challenged the selection part. She sought on parity with regard to that persons at Tiwari and the Babita Devi and Jaishri. So this 3 aspects, the tribunal has not left any one aspect. The 3 aspects the tribunal has considered. The tribunal gone into the orders of 2008. The 2008, if at all I could understand what 2008. In the between, if you say that Manjula and Pushpa Devi, the order has been passed by this honorable court, affirmed by Supreme Court. What prompted them to take plea of that order before the tribunal? Why she has not made any application for seeking the benefit of that order? She is emphasizing a cause of action which is in 2015. And that to be based on a regular selection process, she become participated unsuccessful, and she is saying that I should be regularized again that notified vacancy. No, that is not the case at all. Manjula and Pushpa, again that vacancy notice they are not claimed. They said when you are being given to Manjula, Pushpa says I should be regularized. And this embargo with regard to the order passed by the tribunal that the regulation cannot be granted to her, that was not the order which is staring at the face of the present applicant herein. The principle of res judicata will apply. Once the tribunal has decided the issues and which attain finality, that cannot be reopened again and again with subsequent proceedings. This is my respectful submission. I just show the first order, whereby the person been given on contractual offer. What are the terms and what are the modes of that appointment? I will name on that. Lord, may kindly come to page number. Page number 82, my lord. The director of Andaman Nicobar, my lord, 81 and 82 are the first initial orders, my lord. I take it to my lords to 82. that is order dated 19 March 2002, order number 1469. The Director of Education, Andaman Nicobar, has been pleased to order the engagement of the candidates mentioned in annexure to this order to the post of craft instructor on consolidated pay of 800 per month with effect from the date of the reporting for duty for respective place of posting. They are posted in school mentioned each in the annexure. Their engagement as a part-time constant only up to the closure of school for summer. No, they used to work continuously. They used to till the period of, it is mentioned, closure of the school for summer vacation 2002, and thereafter and their engagement are liable to be terminated at the time without any notice. So from time to time, whenever the part-time would been allowed for a particular period of time after closure of the school, they, as per the order, it is specifically mentioned. But the question about the other side is raising, the only aspect is I've been allowed to continue. I've been allowed to continue. She has allowed to be continued in terms of the order passed by the tribunal. That is in 2008. The three principles which is laid down in Umadevi para 53, that without intervention of the court's order, she should not allowed to be continued. Then only the case will be considered. Against sanction post, and if there is an irregular appointment, that can be rectified by the court. These three aspects she is not fulfilling. May kindly see, the appointment which is she has been engaged in terms of the tribunal's order. Tribunal specifically told to continue her. We have been continued. This is my respectful submission. I board on lordship for my submissions. And with regard to judgments, what my sister, learned senior counsel, is pointing out, these all are judgments which related to the regulation, and this particular case, they are not to be participated and thereafter claiming for regulation. This is a case she participated in the selection process. That is a differentiation between these judgments. So this is my respectful submission.
Your Lordship, my submission is that in 2008, when the tribunal passed the order, what the tribunal has said that she may be permitted to participate in the regular selection process, and till such time she may be allowed to continue. That is the order, Your Lordship. I don't think that I have added anything or deleted anything. It's clearly said that she may be allowed to participate in the selection process, until such time she should not be disturbed. Now, they have taken a decision in 2015 on their own by saying that they have limited the age and declared me ineligible. Now, in 2015, they took a decision which is practically contrary to the decision of the tribunal, because tribunal has already asked them that you have to allow me to participate in the subsequent selection process. That was in 2008. You took a decision to advertise the post in 2015 on your own.
I stand corrected.
Just a minute. 9.
In terms of the recruitment rules, I stand corrected. I'm sorry.
9, 10, Your Lordship, after 7 years, you took a decision to fill up the posts. After 7 years, in 2015. And you did not allow me. You did not follow the decision of the tribunal. That particular thing, along with other aspects, were challenged, because authorities cannot blow hot and cold at the same time. You say that it was for the purpose of, they are relying upon the decision of the tribunal, and they're saying that I cannot be regularized because that decision is there. When they're relying upon that decision, why you have not followed that decision? You should have permitted me to participate in the selection process. You have made me in the ineligible list when the tribunal has already said so.
2009, 2011 and 2015.
In none of the they have allowed me to
9
participate.
and she's
Show.
the tribunal has said 4 occasions.
No, Your Lordship. Only in 2015.
Another advertisement here.
In 2015, they have put me in the ineligible list. Sure. No, Your Lordship. It's not there. No, where it is there.
I think my sister.
Tribunal is tribunal. You show from your reply.
Yes, my lord. I can show it that records, but I don't know whether it is enclosed because it is, she has participated. Yes, ma'am. I'm just.
Let him take care.
I'm just taking it.
Yes. I don't know, Your Lordship, because I haven't seen it. That in 9 and 11 she has participated. I haven't seen it anywhere. In any circumstances, let us assume, Your Lordship, in 9 and 10 I participated. Let us assume. From 2008, I failed. In 2009, I failed. He says, I participated, I failed. Why did you continue? from 2009 to till today? What was the reason? You are taking my service, Your Lordship, up to from 2009 to 2022 also, it is more than 15 years. It's approximately 15 years. It's above 10 years. Even if I failed in 2009, if their case is accepted that I failed in 2009, but you allowed me to continue from 2009 to 2022 and now also, then also in terms of the judgment of the Honorable Supreme Court, I am entitled for regularization. Your Lordship, it's and what Your Lordship, they are saying that those persons have participated in the selection process and thereafter they have been appointed. Your Lordship, the authorities, I will say, they're so clever that what they have done in the case of Manjula also, they said the same thing. That Manjula participated in the selection process and thereafter we have appointed her. After the order passed by the Honorable High Court, they said Manjula participated in Pushparani case. When I filed Pushparani case, they said, I said, Pushparani also should be appointed like Manjula. I said so. Now what they say, Manjula was appointed after participating in the selection process. The Honorable Tribunal said, show which selection process she participated. They were unable to show it. And the Honorable Tribunal has held that Manjula never participated in the selection process. I can see, Your Lordship, page number 230. This is a Pushparani which was ordered. There also they said the same thing. They are playing with the life of an individual, Your Lordship. What the authorities are doing. Paragraph 7, 233, paragraph 7. On the other hand, Shri S.K. Mandal Leonard Counsel appearing for the respondents by opposing all the OA averments has drawn our attention to memorandum dated 5/7/2012 and the minutes of meeting of selection committee dated 24/8/2010, wrongly recorded as this, submits that the case of the applicant and Ms. Manjula are different. Ms. Manjula was appointed after she participated in the selection process and hence the applicant cannot claim appointment without participating in the selection process. Mr. S.K. Mandal and Counsel for the respondent also submits that Ms. Manjula was within the age limit prescribed, whereas the applicant is overaged and as on today's is 56 years old. Hence, her case cannot be considered for appointment. More so, the applicant is not identically placed as Ms. Manjula. In view of the aforesaid rival submission, we have carefully examined the orders of the tribunal in OA number this, and the memorandum dated this, and the minutes of the Department Selection Committee dated this. The memorandum dated 5/7/2012 read as follows. No, Your Lordship, this is in compliance. Now, Your Lordship, may kindly see the observation. Though the memorandum dated 5/7/12 refers to a trade test and interview, but the minutes of the Department Selection Committee dated this nowhere mentions that a said Ms. Manjula participated in any trade test or interview consequent to the memorandum dated 5th July 2012. In the absence of any reference by the Department Selection Committee and the consideration of the result of trade test and interview of Manjula, it cannot be said that she was put to any trade test or interview. They tried to mislead the Honorable Tribunal by saying all these things, showing memorandum, but they tried their best. But records would show, Your Lordship, if somebody is participating in a trade test and an interview, there will be a result of the trade test and interview. Nothing was, they were not able to show. Same tactics now they are doing. Ram Prakash Tiwari and that particular person, they have participated in the selection process. Now, Your Lordship, may kindly see the order of the that Ram Prakash Tiwari. They have said, they never said that participated in the selection process. No words are there. Departmental Selection Committee recommended. That is the only sentence. Where is the result of the Ram Prakash Tiwari? Let them show. Jai Shri, let them show. Even before the tribunal, they were unable to show. Same tactics they applied in Manjula also. Manjula, they were caught because the court said you produce the selection committee's result. They were unable to do it. So these things they have been doing since the beginning, here and there, Your Lordship. And now they are saying that they will not consider my case. I am 56 years old. I have reached up to this age. That's what I am submitting. In 2009 I failed. 2011 I failed. 2015 I was in the ineligible list. Then why? Why till today you are allowing me to continue?
Lordship, that is page number 166. That Lordship is asking whether she was participated after the
What is this? This is not the selection process, the
Next,
advertisement.
next. 167,
166.
167.
Oh,
23-10.
Result there.
So in this not qualified in the selection
What
process.
qualification? This
If you want the result, this we can put it. That's
where's the selection?
Lordship,
That's what I'm saying. Let us
She-
debate. Let us.
Lordship want to
And-
know whether she has participated in subsequent selection process or not. She has participated. Our application is that application is dated 23-10-2009. 23-10-2009.
So let us
She
assume,
has
your lordship.
participated, my lord.
Let us assume that I participated.
If she is,
I
she
participated.
has been.
Now, your lordship, one thing is there.
But
I
now
have
my
point-
sister is making.
No. I have argued earlier itself. Then let us assume that I have participated in
now
2009.
let us-
That I have already argued. I have participated, let us assume. I failed. Of course I failed. Otherwise you would have appointed me on regular basis. Then why did you continue me up till today? 2009 I failed? Is there any answer to that?
No, continue. But I can show it that 11 is not there, my lord, in this. Because 2009, 11 she has participated, then 15. Not, she could have been said, it is admitted. 9 she then, yes. 9 she was there, she was unsuccessful. She's 9. 11 is also there, my lord. I can show it from the records. If my lord want, let me fix it on tomorrow or Monday. I can bring that record of 11, whether she is participating or not. Because
Your lordship, what my contention is that.
she is not denying if 11 she.
Your lordship, they are unable to answer anything with regard to Pushpa Rani and Manjula.
No, then,
This honorable, just a minute, this honorable court, being the honorable High Court, your lordship, can consider all those aspects and pass an order. But if your lordship feels that these are relevant things, Pushpa Rani and Manjula, and the tribunal could not consider it, there are two options, because this particular petitioner is at this age of 56 years, your lordship. So either this honorable court can look into it, because when I have taken a plea with regard to this, these are decisions of the court. It's not that I am telling some facts. Decision in Pushpa Rani, decision in Manjula. Those are decisions of the courts which I am placing. If your lordship feels, and they are not saying that I am different from Pushpa Rani or Manjula, because
I said it, Lord.
beyond record, when I'm showing the appointment orders all up from this page number 86 to 144 pages, where our three names appear together, can you say that I'm different from them? On what basis? I am showing document, you are just verbally saying. I am showing the orders of the courts, orders of the authorities, but you are simply saying, without any document, that all these three persons are different. On what basis you are saying? Simply, like that. Pushpa Rani participated in the selection process. It is, they recorded in the order also, she failed. Similar situation like that. If you say in 2009 I failed, exactly the same situation as that of Pushpa Rani Viswas. And the court considered, relying upon the decision of Manjula. Your relief can be granted by this honorable court considering the peculiar circumstances of this case, because she is still working. Or else, if your lordship feels that no, Pushpa Rani Viswas and Manjula's case have to be looked into deeply, and these facts cannot be done by this honorable court, it has to be remanded to the tribunal. These are the two things which I would be insisting for the disposal, because she's at the age of 56. It's totally upon your lordship. But they cannot say, your lordship, Pushpa Rani and Manjula are different from me, because appointment orders show that all three of us were appointed together. And Pushpa Rani Biswas participated in a selection process, she failed.
No, let them show that Pushpa Rani, Manjula, the tribunal has passed any order that they are not entitled for regularization. No, the 2008 is starving on their face, my lord, which is attained finality. That was not the case of Manjula and Pushpa. That's why from the beginning I'm submitting.
Similarly,
She admitted the position. When you himself admitted, you cannot re-agitate again and again. Sir. Blair.
Like,